Okay, last week we briefly covered different type of organization, so proprietorship, partnership, limited liability company, and corporation. And we're going to actually go into a little more in detail on corporation today. However, before we go into corporation, let's go over the questions that we had last week. Now, what we studied last week was Uniform Commercial Code. Specifically, Article 2. And basically, UCC Article 2 covers the rule for sales of goods, right? So common law covers contract for the sales service contract, but Article 2 UCC cover sales of goods. So let's go through these questions first. So I'm looking at on the top said Chapter 18, formation of sales and lease contract. Okay, number one, it says Article 2 of UCC is also applied by federal court to sales contract governed by federal law. That's true. It covers sales of goods. Number two, Article 2 of UCC applies to sales contract for sales of intangible good. Now, when we say sales of good, it means tangible good, not intangible good. So that's false. Number two, if a person buy a computer, set up contract for it would be subject to Article 2 of UCC. A computer is tangible product, and we call it good. So that Article 2 applies to that. Number four, contract for provision of service are not covered by Article 2. That's true. Sales of contract, service contract is covered under the common law. Number five, Article 2 of UCC defines a merchant as a person who deals in goods of kind involved in transaction. That's true. Last week we studied that under the UCC, merchants have special provisions. Number six, Article 2A of UCC deal with lessor or lessees. Yeah, we didn't really go into detail on lessee or lessor, but that's under Article 2A. Number seven, in a lease contract, the term of title is passed from the lessor to lessee. Now, the difference between sales contract and lease is under the lease, the title is remained to normally to the bank or financing company. So it's called lessor is a bank. So lessee only have right to use the good. Like if you are leasing your car from the Mercedes-Benz financing, Benz financing company will hold the title of the good, but you have only right to use the Benz during the term of the lease, right? So that's false. 8, the UCC does not allow for open terms to be read into sale or lease contract. Why is it false? Anybody want to comment on that? Okay, it's false because under the UCC, as long as there is quantity in the term, the court is willing to acknowledge a reasonable term. So under the common law, all the 5 different terms has to be there, but under the UCC, as long as quantity is there, then court will try to apply the reasonable term. Number 9, the parties to the sales contract do not agree to time, place, manner of delivery of the goods. Place for delivery, if the parties to the sales contract do not agree to the time, place, manner of delivery of goods, place for delivery, is the seller's place of business. Like, I think it relates to question number 8, that if the contract doesn't specify, like, definite time, place, manner, as long as there's quantity, court will acknowledge that contract as a valid contract. And the valid delivery place of the delivery will be seller's place of business. Number 10, the open price term requires for contract to mention specific price. Again, under the UCC, as long as there's quantity, court will sometimes apply reasonable price. So that can be basically open price. Number 11, formation of sales and lease contract requires consideration. That's true. Now, basically for the contract to be valid, there has to be offer, acceptance, and consideration. 3 elements. Number 12, formal offer rule allow offeror to revoke an offer at any time prior to acceptance. What's the firm offer rule? Anybody remember? Now, firm offer rule under UCC is between the merchants, that when the two merchants basically agree to give an option to other merchant, as long as one of the merchants send a simple notice or simple memo to another merchants, they cannot basically revoke the contract. Number 13, if one or both parts of the sales contract are merchant, any additional terms are considered proposed addition to contract. Now, I'm not sure if you remember, under the merchant special rule, if the merchant add additional term, it automatically become part of the contract unless that additional term materially alter the contract. Now, all these are very specific rule in UCC, so like I said, we went pretty fast, so I don't expect you to memorize everything. But who knows, this might be in your final exam, right? So later on, you might want to review this question once again. Okay? But like our midterm, as long as you review your quizzes, you will have no problem for your final. And I told you, our final will be on the subjects that we learn after the midterm. So which means you don't have to restudy the first part of our, the subjects that we studied before the midterm. Only reason I'm doing that is because there are too many detailed subjects that we are covering, and I think it would be too much for you to memorize everything. Okay, 13. 14. You guys need to. You guys have a chair? We have one chair.
Yeah, one more. You can bring from there.
Can you just grab one chair? 14. Under the common law, additional terms in acceptance of an offer are considered counteroffer. That's true. The 13 and 14 is related. Under the common law, if the offeree who accepts the offer add additional term, that becomes counteroffer. However, under the UCC, between the merchants, it's getting a little hot here, when offeree add additional term, that become part of the contract, unless that additional term materially alter the original contract. Now, all these, I am actually saying it pretty fast, but all these are very detailed rules in UCC. So I understand that you guys can just memorize it. But for your final, you better study this. Okay, 15. Written confirmation rule requires requires that both party to oral agreement. Oh, come on in. Well, actually,
Yeah, I'm gonna be
one is
leaving.
leaving, so I think you can sit over there now. Okay.
This man is fairly.
I haven't even gone into comments yet.
Sorry.
Okay. Okay, 15, written confirmation will require that both parties of oral agreement send written confirmation of sale. Written confirmation. Both parties. Actually, for 15, the only thing, what is wrong there is only one party, not both parties. If any one party send a written confirmation, that is sufficient. So what is wrong is not both, it could be only one party. Chapter 20, let's not get into chapter 20. Don't worry about chapter 20 in your, because I think it's just going into too much detail, and I don't think you guys really need that much detail.
So, chapter 20,
Chapter 20, no stuff.
cross out?
Yeah, cross out.
So, तो आप उन तारीखों को
Okay, let's go into a little bit on this corporation stuff. We covered type of business organization last week. I will not actually go into review corporation once again. But let's focus on now, why do people form corporations? What would be advantage forming corporation?
Limited liability.
Yeah. One would be limited liability. Then maybe another could be you could have an unlimited number of investors.
Yeah.
So what happens is when company actually wants to go to public, last week I told you if you can make either your own franchise or if you can bring your corporation to public, yeah, you become millionaire. Guaranteed. So a lot of people try to bring their company to public. So then why can't everybody go into the public? Because there are regulations, so-called SEC, so Security Exchange Commissioner. We have Security Exchange Commissioner regulate those companies who can sell to public. Now, Security Exchange Commissioner was formed in 1933. What happened in 1933 in this country? In 1933, our stock market crashed. So we are a capitalist country, and in the capitalist country, our foundation is basically this financial market. What's the financial market? The financial market is where we have
Lending money.
investors, like many investors. Then we have these companies, and there are basically some kind of system where investor can choose, because there are so many companies there. And how does investor know which company they can invest? So the problem before 1933 was we did not have a system where investors can get enough information about these companies. So what the system they created was they create some type of system, so more like it's called disclosure requirement. So SEC, this organization, does not guarantee that this company will never go bankrupt. They go bankrupt. But what SEC tried to do is, whoever wants to sell their stock to public, they have to disclose certain information. So disclose certain information, normally going into like, such as prospectus. Prospectus means their, financial projection for the future, their history, current situation, their projection for next 5 years. And they also have audited financial statement. What's the difference between non-audited and audited financial statement?
Audited financial statement and the common investor, they can believe about what actual scenario of the company, but non-audited, it is some like the false statement or something like that.
Yeah, so basically, audited financial statement is audited by, let's leave it open. It's audited by CPA, auditor, saying, I reviewed all their number, and their number seems to reveal true situation of the company. So basically, SEC also require that if somebody want to go to the public, they need to have a minimum income, and they need to be in business more than 2 years, and secondly, they need to have a certain minimum asset, and basically generate enough income. Then they require them to provide all the necessary documents. Then SEC say, okay, your disclosure is sufficient for investors, then they will approve. We're gonna go into more detail that not every company needs to get SEC approval. There are some exemptions, and we're gonna go into those exemptions later. So, one of the problem actually, we talk about in business law course, we also supposed to talk about ethics. And I think Dr. Son, when he came in last time, he showed some ethic video, I think. Now these ethics became very sensitive issue because a lot of companies, they try to put wrong, fake number into their financial statement. Now you might say, well, I don't understand. If somebody is auditing the financial statement, how can they put the wrong number? Now, they can. If you actually take some accounting course, they can manipulate some accounting numbers. like they supposed to, if to increase their profit, maybe they don't put all their expenses. They intentionally omit expenses. What happens if they don't include all the expenses? Income goes up, right?
Yep.
Then I think what's the one of the famous company in this era, Enron crisis. I think we heard that Enron. We're gonna actually go through Enron crisis again. What Enron company did was I think first, what was their primary business? I forgot what was their primary business. Their primary business was successful, then they tried to expand their corporation. Then they created many so-called paper company. What's the paper company? Just formed in name only. So they made a lot of paper company in foreign corporation. So Enron actually made, Enron Corporation is in the US, then they made many foreign actually companies which actually do not operate, but it's only in paper. They formed a corporation in other countries, and they basically delegate all the basically negative income, negative actually losses to foreign companies. So it looked like the main company looks like having positive income, but in a way company was operating in loss, but they basically manipulate their financial statement. So it looked like their head corporation is making enough income, but that's actually when they were not. So basically, the CPA company who audit their financial statement was, I think Anderson's, what was a famous company, Anderson Brother or something. Anyway, they were one of the big CPA company, and they also had to file the bankruptcy as well. So with the Enron crisis, what happened was, before that, this white collar crime was not really that serious matter. Whenever the corporate officer manipulate their financial statement, it was very hard for government to charge them criminal offense. Because normally they could be only liable for civil matter. Why? Because for the criminal, somebody to be liable for criminal means they are going to prison. They must have an intent to deceive. Their original intent was to deceive somebody. So somehow before Enron crisis, many executives, even though they did security fraud, they didn't go to jail. They simply paid a penalty. But after Enron crisis, basically. Oh yeah, no problem. If you have to sleep, you have to sleep. No other choice. No, don't worry.
Last week you said something about federal courts trying federal cases.
Huh?
You said something last week.
Federal crime. Anyway, we'll get into more detail what kind of offenses. Actually, today we're gonna go into a lot of detail. It's already in your handout, but I don't expect you to memorize everything, because some of the handouts are for CPA exam also. Interestingly, this course is mix of law school courses and CPA courses. It means it's going to a lot of detail, and it's going to too much in detail. So, whatever we cover only in quizzes, that's all you guys need to worry about. But as we are learning, I got to give you the detail. But, you keep that in your file, then later on, when you happen to buy your own stock, or, when it's time for you to invest, or you have opportunity to open your own company, you can look into your note and see. Now, with these things, you scan everything and you just save everything in your hard disk, and sometimes that's your library. So. But at least you know what's out there, what kind of, SEC, who has to register to SEC, then if somebody does wrong, what kind of offenses that can be charged against you. So we'll go over those questions. So let's begin with, I think I put a number at the bottom. Number 1, we went through that last week. Let's take a look at page number 2. On page number 2, you compare corporation with other businesses. We also went through that. Now again, the handout that I give you today, we're not going to go over every detail. Again, this handout is also for, I use this for law school class 2. So it doesn't. So we're not going to go through every detail. Okay, now let's start with the forming corporation. To form the corporation. So let's start from how to form the corporation. Okay, to basically on page 3, on actually B2, to form the corporation, we have to file article of incorporation. And in the article of incorporation, you need to include name of the corporation, number of share, number 3, street address of initial registered agent, and number 4, name and address of each incorporator. So in the article of incorporation, if you happen to want to set up your own incorporation, you can just go into internet and just type article of incorporation in Virginia, and you will just show you the example. If you go to attorney, he's going to charge you the same thing you can do for $1,000. So why waste $1,000? And also B, you don't really have to put actually like business purpose. Normally for business purpose, we normally put any legal business, whatever the business we can. So we don't. Some people will just say, "Oh, I'm gonna do childcare business. I'm doing, this corporation will be school, or some wholesale." But you don't really have to specify the detail. You can just say, any legal business that which is not violation of law. You can make that broad statement. Okay. Now on C, basically, it goes into de facto corporation, or that, but that's going into too much in detail. Normally, let me see, article of incorporation, and now this bylaw, bylaw actually, this you file to Department of Corporation, but bylaw you do not file at Department of Corporation. Bylaw is basically how the corporation will run. But basically bylaw, there's also minutes of meetings. These two will be kept in office of the corporation. Again, these sample bylaw can be easily found in internet. You don't have to hire an attorney to create your bylaw. Only requirement, corporation law requirement is they need to have a meeting once a year, board of directors meeting. So these two, basically, these two are internal files, and only this one is filed at Department of Corporation. And every year, the corporation has to pay corporation fee. Corporation fee is normally, in California it was $800. Virginia, I'm not sure. But you know what happened? If a corporation do not pay that fee, when they get into the lawsuit, they automatically lose if they don't pay that $800. So I had some instance previously that some of my clients, I didn't know they didn't pay the yearly fee, but let's say they got a lawsuit from somebody, then they came to me and I was gonna defend their lawsuit. The plaintiff said, "You're lost because we checked your record at Department of Corporation and you guys didn't pay your $800 fee, right?" Then I said, "Oh, not so fast. We can still pay, and we can get back into the fighting." And then we have to go to the court and tell the judge, "Judge, this is unfair. Just for $800, we're not gonna lose $500,000 loss. So allow us to pay that $800 as penalty. Then we'll get back into the lawsuit." Normally, judge will approve it. Judge will not say, "Too bad, you lose it, $500,000, right?" But initially, so when there is a lawsuit between corporation, we always check other parties' record, Department of Corporation, whether the fee has been paid. If they haven't been paid, we said, when they filed the answer, we said, "Your answer is no good because you guys didn't pay the fee. You guys lost already." But that's, we can always, track back and pay our fee. Okay, so let's continue. Now on the page 4, there are terms called corporation or pierce the corporate veil. We call now piercing corporation veil means normally if somebody found a corporation, then his liability is only what he invests into the business. But let's say this person has a lot of asset, means he has his house, he has his other commercial property, and his business is going bankrupt. Then from attorney point of view, even though we get judgment, it means nothing because his corporation doesn't have enough money. So what we try to do is pierce the corporate veil, means we try to convince the judge that, you know, his corporation is only outside, it look like corporation, but he operates his business like his own business, you know, corporation. So to prove that, we are saying, well, he has no record that he did annual meeting. Then what's the another thing I told you, a lot of Koreans make a mistake. They mix the corporate bank account with their personal bank account. Normally, whenever there are only two ways to withdraw the money from the corporation. One will be salary, another will be dividend, which is return of the profit. But many Korean, although they formed a corporation because they heard that it's good, they really did not manage the corporation like corporation. So when they are paying their house mortgage, they write their corporation check. When their daughter said, I need pocket money, they write their corporation checking account. So they are using corporate checking account like their personal check. Now if we can prove that, we tell the judge, you know, from outside, name is corporation, but he did not operate a corporation. So we say piercing corporate veil, so we can go after his personal asset. But that's the only term in the lawsuit. Okay. On page 5, capital structure. Capital structure. Now, corporation, if they need money, where do they find the money? Number one, initial incorporated investment, right? So let's say you form the corporation, and you initially put, let's say, $100,000 to form the corporation.